All right. Good day, ladies and gentlemen. Once again, I'm attorney Brenton Boyce, and this is Courtroom Testimony, CRJS260. And tonight I'm here to lecture on Chapter 5 of our textbook. And the textbook is Winning Courtroom Testimony for Law Enforcement Officers by Matthew J. Medina. So we'll delve into Chapter 5. The last chapter we talked about was Chapter 4, which was persuasion. It was a quick chapter just on not saying you as a witness have to come in there to persuade, but showing how your testimony and how your testimony is used in a building block in building the case for the prosecution or whoever's calling you, the litigant is calling you. So it's their job to be persuasive, but your good testimony helps them be persuasive on the back end. That's chapter 4. Now let's move into to chapter 5. Another important part of helping the litigant that's calling you or helping to advance the case, and this is courtroom demeanor. What I tell people all the time is that evidence is not just those physical things that come into court. Evidence is first and foremost testimony. As a matter of fact, all physical evidence that comes into a trial must first be testified to. That means someone has to come in and talk about what it is, how it's connected to the case, the chain of custody. So it has to be testified to before it even gets in and becomes physical evidence. So testimony is the ultimate type of evidence. So we have testimony, we have physical evidence, and then with testimony comes the person who is testifying. So you as a person, what you have on, how you're perceived, how you look that day, your attitude, all of this becomes evidence as well. I know it's unfair, but all of it becomes evidence. How you're perceived, how you come off to people, how you dress, whether you act like you don't care about the case, all that matters. All of that now goes into whether or not a jury is going to believe what you're saying. So it's important. Now, chapter 5, courtroom demeanor. It starts off by saying, just relax, be yourself. You have nothing to worry about. But that is easier said than done. Nervousness is just something it's hard to get over. A lot of people aren't natural public speakers. There's some people, even in being natural public speakers, they still have nervousness. And sometimes the nervousness helps them, right? And they get over it and they get through it. Once the first word comes out of the first sentence and they get some reaction from the crowd, it's like the nervousness is gone. Now they're at home. But a lot of people, the average person the average person isn't a public speaker. So you're going and testifying in court is public speech. Depending on how many people care about the case and how packed the courtroom is, that's going to matter about that's going to determine how many people are in there. So I'm assuming most people can speak in a room of 20 to 25 people. You got 12 juries. You might have 4 or 5 people on each side of the litigant tables, and then you got one judge. You probably got bailiffs, and you got a bailiff or a team of bailiffs, and probably the court stenographer and the courtroom clerk, and so they're going to be in most courtroom settings in a jury trial. There are probably at least 25 people in the courtroom, which is not a big crowd to speak in front of, but you never know a person's level of comfort with speaking in front of people. So either way it goes, it is public speaking. A relaxed witness is more effective than a nervous witness. How a witness acts and how a witness looks is almost as important as what he or she says. And that's true. Like I just said, how you're perceived is just as much evidence as what you say and what physical evidence comes in. Because if you're perceived a certain way, I hate to say it, but what you say, what comes out of your mouth may not even matter. I know it's true we ought to judge people impartially. We should listen to what a person says and judge that person on the logical coherence of his or her statement and the plausibility of the story, and not be unduly influenced by how he or she looks. This, however, is not the world we live in. It just is what it is. Jurors are people, just like the rest of us judge people based upon how they look and without them saying anything. Where do you think the jury pool comes from? It comes from us regular people who do regular people things, and and take the easy way out by just judging people based upon how they look. That's just who we are as humans. It's not a great thing, but it's something we just have to get over and work around in the court system. You have to just adjust and understand that people are going to judge you. When actually, I talk about the Trayvon Martin case, the young lady that talked to him on the phone right before he got shot. How she was kind of badgered, just not only in the public eye on all the news junkets because she was a little ghetto. She spoke broken English. She talked in colloquialisms and stuff like that. So they tried to discount what she said as not being true, not because it wasn't true, but because of how she was saying it. And that was super unfair, but that's the reality of the world we live in. And a lot of times these biases are based, especially when it's black people testifying, they're based on race. Because sometimes there's some people in certain communities, whether it be black or other communities, they lack the ability to code switch effectively. You know what code switching is: when you talk a certain way with the homies, but then when you're in a professional surrounding, you adjust it and you talk differently. There's some people who just don't do a good job of switching over, crossing over, and code switching. So even in court, they talk the same way they talk in the street. So sometimes there's a whole different vocabulary that the majority of society, not being from certain cultures, just doesn't understand. It goes right over their head. And we talked about being understandable, and how being understandable is an important part of being believed, and it's an important part of your testimony being useful. So it's unfair, but it's just one of those things we have to live with. How people judge other people in the real world, that's what it is. That's what this chapter is about. Courtroom demeanor. You should be, even if you come in the courtroom with your pajamas on, if you're telling the truth, it's the truth, and we should take it. But it's tough because we ask the jury to listen to what everyone says and make decisions based upon testimony, and truthful testimony, and take what people say. But we also ask them to judge credibility. And because it is what we call an adversarial system, credibility is always in question from the opposing side. So that kind of, even though we're asking the jury to be impartial and kind of don't worry about how a person looks and just listen to what they say, we also have an opposing side on both sides that are going to essentially attack each witness. So credibility is always in question. So that means the juries, in and of themselves, they have to judge credibility. Sometimes in certain cases, you might have one witness is saying one thing and one witness is saying the exact opposite thing. At the end of the day, who do you believe? Sometimes these witnesses are equal. There's nothing to really cross-examine them about. In the vast majority of cases, these things don't happen on videotape. You have one person saying, this person punched me in the face, and the other person saying, I didn't punch him in the face, he punched me in the face. So there's usually nothing about it to say, who did what. Sometimes in these cases, they don't have pictures to say, well, if he didn't punch me in the face, why do I have a black eye? Sometimes they don't have a picture of the black eye, or they don't have a black eye in court. So the jury has to essentially pick who they're going to choose, because if they determine to acquit this person for assault, that means the jury believed that he didn't punch that person in the eye. If they are going to find the person guilty, that means that the jury believed that he did in fact punch the person in the eye. So if they're both saying opposing things and all we have is their testimony, what was the difference? And the difference is credibility and sometimes courtroom demeanor. And so I always tell my clients or people I have testifying in my trials, the devil is in the details. So it's not just about your demeanor, but when you're giving testimony, if you give detailed testimony, like not just we were outside chilling, we were outside standing there. We were standing beside Reggie's car. Reggie got the gray Honda Civic. I had on my white T-shirt because that's the T-shirt I hoop in. Old boy had on the Jordans because I was like, those 11s. Little stuff like that is more than just, we were outside chilling and he hit me. Would you believe we were outside chilling and he hit me? Or would you believe, he had this on and that on because I remember I was standing there, that he came at me and he swung at me And I was like, and I reared back and dodged it. Then I swung at him. You know what I mean? So it was self defense. So in that situation, what's more believable? The story where someone just says something in general, or the story where someone says something and they have details, and this person has details and they're dressed impeccably and they're speaking in a certain way that the majority or the people, what do I say, the majority culture likes. So that means they're going to come off as believable. So body language, not slouching, being interested in what's going on, or seeming interested by the way you're sitting, and the fact that you care about what's being questioned, looking person in the eye, maybe leaning forward, leaning back, and little stuff like that matters to a jury. It's, a person could do all that and still be lying through their teeth, but it's not just about telling the truth. It's about being believable, having a believable demeanor. So I hate to say it, but all that's included. It's not just about what comes out of your mouth. It's about where, whose mouth it comes out of and what the perception of that person is. It's bad that we have to say that, but it is what it is. So let's see. Jurors are influenced either consciously or subconsciously by many factors. How a witness dresses, the manner in which he inflects his or her voice, whether he or she uses big or little words, whether he stutters or does not stutter, if he rambles or speaks in paragraphs, if he taps his feet or fingers, or if he sits still, whether he or she speaks quickly or slowly, or loudly or softly, whether he sits up straight or slumps in his seat, whether he acts politely or snarky, whether he appears condescending or genuine, whether he makes eye contact, or if so, to whom, if he smiles or doesn't smile. And yes, the jurors will take notice if the witness appears nervous. And, there's nothing about nervousness that means you're not telling the truth. But a lot of times people take nervousness as he's lying. It's like people all of a sudden become psychologists, even cops. You seem nervous. Something wrong? It's like, no, you're a cop. I'm just, I don't want to be here right now. Yes, I'm nervous. So it's like nervousness all of a sudden becomes this gauge to tell whether someone's up to something, or whether they're nervous, or whether they're lying. I mean, whether they're nervous, whether they're lying. It's crazy how that happens, because nervousness is a natural reaction. It's something we all experience when we're in uncomfortable or uncharted territory. So the above factors have little to do with the substance of a witness's testimony, have nothing to do with whether or not it's true, what happened or what didn't happen. Yet these factors do matter precisely because people and jurors think they matter. A large part of communication is nonverbal. Like I said, the first communication you make with the jury is when you walk up to the jury stand before you said a word. It's how you dress, how you carry yourself, how you sit. All that stuff matters. When you testify with your dress, mannerisms, voice tone, eye contact, facial expressions, and posture. There are certain characteristics that communicate to people that you may be untrustworthy and that you may be trustworthy. So you would rather be trustworthy than untrustworthy, right? You can tell the truth till the cows come home. However, if the jury doesn't believe you, it doesn't matter. In addition to telling the truth, you also want to appear as if you're telling the truth. So not only do you want to tell the truth, you want to appear as if you're telling the truth. So it's all smoke and mirrors, but it's not lying. We're telling the truth, but it's all about the package. Nervousness versus confidence. Nervousness is not a very accurate sign of untruthfulness, but people take it as. Signs of a person's nervousness include such physical attributes as fidgeting, sweating, verbal stammering, and lack of eye contact. What matters is that many, if not most jurors and judges believe that nervousness is an accurate sign of deception. So it just is what it is. The best way to fight nervousness is to be prepared and be confident. If you've come to court prepared, it doesn't mean you've rehearsed. And you've committed things to just memory. It means you know them. You've tried to, know what you're going to say, so that because it's just like going in to take a test. People are nervous if they're not prepared and they haven't studied, right? I'm about to make this F because I ain't look at it, so you're nervous. But if you studied and you're ready, and you go in there, you're like, yeah, bring these questions. I'm about to get an A. So it's the same way in court. When you're prepared and you have a certain level of preparedness, that is going to combat nervousness, no matter how many people are in the courtroom. So that's nervousness versus confidence. Then we have defensiveness versus openness. Avoid the universally recognized posture of defensiveness, folding your arms, and having a frown, or seeming not open and not open and not nice to the person that's questioning you. If you're not nice, especially doing cross-examination to the person that's asked you cross-examination questions, even though they're the opposing side, the jury is going to say, well, based upon the way this person's acting, they may also not be answering this person's questions truthfully, just because look at their posture. If you exhibit defensive posture, jurors will think that you have something to hide. You want to be an open book. If you're an open book, the jury will trust you and they'll say what you're saying is the truth. But if you seem defensive, then now you look like a closed book, like you're not open, not feeling like answering questions. A jury will not trust you in that situation if you're locked up and defensive. You can lose the trust of the jury simply by exhibiting defensive or slack mannerisms. So not even seeming interested in what's going on, the slouching like you don't care. That matters. The jury's going to say, well, that person doesn't care, so why should we care about what they have to say? That person doesn't want to answer questions openly and just answer the questions, so they're probably liars. As confidence is the flip side of nervousness, openness is the flip side of defensiveness. Openness shows sincerity. You can exhibit openness physically by maintaining a natural posture. Most people know that their moods influence the way they look, but it is also true that the way you look can influence your mood. Next, we have cowardliness versus valor. You want to sit up and not slouch, right? You need to keep in mind that this does not mean that you should become stiff and rigid. So sitting up is not slouching doesn't mean you're, act like a dead body on the jury stand and super rigid, like a robot or something. Smile when it's appropriate. Sometimes there's certain testimony that's going to elicit a smile. Oh, yeah, it was a beautiful day. Yeah, she was a pretty little girl. Yeah, you say stuff like that. That's stuff that may bring a smile to your face. But if you say, yeah, she was stabbed 17 times and blood was everywhere, that's not appropriate. That's why we say smile when appropriate. So you want to have the appropriate facial expressions for the mood and what you're talking about. If you're talking about a double murder and getting to the scene and seeing two dead bodies bleeding out and dead, that's not what you're gonna smile about. But talking about who a person is when you met them and they were so cool, yeah, and she said this and that, those are things that can bring a smile or the moment, whatever's going on in the moment. Sometimes, attorneys ask questions in jest, and we like to be loose. And there's nothing wrong with following suit and smiling and sometimes even laughing when it's appropriate. But make sure it's appropriate. If you laugh or smile or even you frown in a situation where it elicits where something elicits a smile, then it's not gonna equate, and the jury may think you're a little off, and you don't want to seem off. So one thing that's worse than being a liar is being off, right? So you don't want to be that way. So do not, like I said, smile when it's natural. If it comes naturally to you, if you're not a natural smiler, then don't be like that, looking unnatural. So just do what comes natural and do what is appropriate given the current situation and the current line of questioning. Of course, also the number one, avoid fidgeting. Try to keep your hands below the bench where they're outside of the views. Like if you like to fidget or do things, the jury can't see it if your hands, like you guys can see my hands now, but if I keep my hands below the table, you can't see them. So even if I am nervous and moving my fingers and popping my fingers, you can't see it. So it doesn't kind of misdirect the attention off of what I'm saying. Some people talk with their hands, and there's nothing wrong. If you talk with your hands, I do sometimes, and it's naturally how you talk, nothing wrong with that. But you don't want to do it to the point where in talking, your hands cover your face. Like right now, if I'm doing this as I'm talking to you guys and teaching you guys, you're like, boy, stop, it's getting on my nerves. But if you're talking like this, yeah, he did that, and I saw he was over there, yeah, and we did that, and I think it was over there. stuff like that doesn't kind of misdirect the attention from this part, what is coming out of your mouth. Then we have evasiveness and directiveness, and this is nothing more than kind of a spin off of defensiveness and openness. Sometimes you can be defensive, not necessarily in your posture, but in the way you're answering questions. If you're being defensive in the way you're answering questions, you're not an open book and keeping it real. Like I said, it's one of those things where the jury's going to feel like you have something to hide. Just like openness is the opposite of defensiveness, directness is the opposite of evasiveness. This is all about how to testify truthfully without looking like a liar. One of the best ways to look like a liar is to testify evasively, to kind of evade the question rather than just answering it. The best ways to appear trustworthy is to be trustworthy. The second best way to appear trustworthy is to be direct. Sometimes, you should even shock the jury with your directness. Just, this happened. We got to the scene late. We didn't respond like we were supposed to. We didn't get there on time. And I feel bad about it to this day. If I would have gotten there, we would have saved those people's lives. So a lot of times people on the stand, they want to come off as so self-righteous. They feel like if I show the jury that I wasn't perfect, they're going to think I'm not perfect now. But that's not how it goes. If you show the jury you're not perfect, they're going to think you're trustworthy now. It's not about being perfect in your job now. It's about being trustworthy and making sure the jury at least trusts what you're saying. Admit when you were wrong. Whether it was something you did wrong, and if you're a law enforcement officer, a wrong assumption you made in your investigation or anything. I thought it was him. I was wrong. It was actually the person that's here today. So when we started off the investigation, we weren't going in the wrong direction. I admit. But once I cleared that from my mind, and I realized that we were going after the wrong person, and that person had a solid alibi. I closed that thought out of my process and opened up to new people that might have been a part of it. And I really started investigating. So when you keep it real and you say, "Yep, I was wrong at first, but I made a change, and I realized the error of my ways, and I changed," the jury's going to think of you as a human. And because you were willing to open that up and put that on the table, that's going to make you trustworthy. Let me see. Like I said, don't play word games. Just admit when you were wrong. If the defense attorney has to drag something out of you, that means that there's probably other stuff in there that you were holding back on, and you're not truthful. The jury will perceive you as more truthful if you readily admit your mistakes. So just remember that. Many completely honest witnesses answer cross-examination questions evasively because they think the questioner is out to get them. And yes, on cross-examination, the question is out to get them. But when you answer questions evasively, you're helping them. They're out to get you. Let me change that. Yes, during cross-examination, the opposing counsel is out to get you. But when you answer questions evasively, you're helping them get you because you're setting yourself up to look like you have something to hide or you're lying. So just even on cross-examination, just be an open book. On direct examination, especially if the litigant has planned well, that means the litigant is already prepared and going to ask you the question to get it out of the way. Like I do the same thing. If I know I have a client that's testifying and they have a criminal record, something that could be used to impeach them for truthfulness, like their criminal record and the convictions within a certain amount of time of the trial, rather than wait for the prosecuting attorney to cross-examine them and talk about what they've been convicted of within the last 6 years that carries a sentence of 6 months or more or something like that. I get it out. I say, what have you been convicted of? And I got that misdemeanor larceny charge. I was hungry, so I stole a Snickers bar. Okay, cool. Does that have anything to do with the case you're talking about today? No. Does you having that prior conviction is that going to affect whether or not you're telling us the truth today? No, that has nothing to do with this. So that gets it out. That opens the book already. So then when the prosecutor comes to cross-examine, it takes the sting out. So when you're open book at all phases, it takes the sting out of what the opposing party wants to do in cross-examination. They can call you a lot of things. They can say you were imperfect in your investigation, but they cannot call you a liar. And that's not what you want. Then we have servility versus politeness. What that means, you don't want to over embellish your what do I call it? Your flattery of a person. Be nice and polite, but don't overdo it. Don't fawn or engage in insincere flattery, because anything insincere to the jury that means everything you did or said was insincere. Most people can see through flattery and insincerity. It makes you look dishonest. You should act in a manner that fits the surroundings. Understand the importance and the pomp and circumstance of court, getting up and all rise, or when the jury comes in, standing up and sitting down. It just is what it is. Also, volume. If you don't normally speak loud, you want to speak loud enough where you can be heard. Because one thing you don't want the jury to not believe you or disregard what you say, because they can't hear you. They gotta reach over and what did he say? So that's what they put at the end of chapter 5. So for the roll, let's talk about do's and don'ts. Do's: smile only if it comes naturally and it's appropriate given the line of questioning or the subject matter. Sit upright, relax your muscles, even if it does not come naturally. Always at least seem relaxed. Not too relaxed, not slouching, but seem naturally relaxed. Keep your hands open even if it does not come naturally. Sometimes it's defensive when you got your fist balled up. You seem mad, and the jury's like, "What? He gonna punch? Is he gonna punch the person asking him questions? Oh, this person's aggressive." So just hands open. Sometimes put them on your lap or whatever. Breathe naturally, or try to. Sometimes breathing can affect, your nervous level and your nervousness level. Make eye contact with the questioner, and also make eye contact with the juries. What we teach, I coach mock trial as well, and witnesses get judged on how sincere, how believable they are. And a believable witness is someone that looks the person asking them a question in the eye, and then they look the jury in the eye when they answer. Where were you on the night of Tuesday? Where were you on the night of Thursday, August 27th, 2020? I was at home doing a video. I was videotaping chapter 5 of my courtroom testimony class. So you see how I got the question, looked in the eye, but I used eye contact directly to the jury, or at best, at least use eye contact back to the person asking you the question, so the jury will see it anyway. Give your answer to the jury, as I said before. I just said eye contact and eye contact when you're giving your answer. So always answer your questions to the jury. So usually a person asking questions, a litigant, is going to be positioned in a place in the court where they're in one place and the jury's in another place. A lot of times, if a litigant is allowed to move around the court as they ask questions, they'll place themselves in a place where it's almost like looking at them while they're asking the question is almost like looking at the jury because of where they're positioned themselves. So you don't have to look here and then look there. If that's in a jurisdiction where they can move around and have free reign of the well of the courtroom. In North Carolina, we're a sitting jurisdiction, so litigants sit while they're asking questions, which seems kind of boring, but it is how it is. So a lot of times, the witness has to look here where I'm sitting, and then look in another direction or look wherever the jury is. So it is what it is. So look, eye contact with the questioner, and when you're answering, eye contact with the jury. Keep your hands away from your mouth. Speak loudly, and just try to relax. Don'ts. Here are the don'ts. Those are the do's. Here are the don'ts. Don't scowl, slump, sway, sigh, slouch, tap, fidget, yawn, or crouch. Now, yawning is natural. Sometimes you can't, but try not to hide the yawn. So, because yawning can make you seem disinterested, even though it has nothing to do with whether or not you're interested. It means you probably should have got some more sleep, or your brain just needs some more oxygen. That's what it means. So also give no false praise. Don't act aloof. If you do, at worst, the jury will think you're a liar. At best, they'll think you're a goof. Jury members will hold it against you if you appear evasive, hesitant, or exhibit physical tics such as twitching, stuttering, sweating, or blinking. And some of those things are natural. You just can't, if you have a stuttering problem or a speech impediment, it is what it is. So that is chapter 5. Once again, at the end of every chapter, you got review questions. Go through them, see what you do well, and you can see whether or not you did well because you can flip the book upside down, and up here they have the answers to the questions. And doing that for every chapter might help you Might. When it comes to doing quizzes for each section. So I'm just putting it out there. So it would help just prepare and do a little extra work and do these little true, false, and multiple choice questions. So that's it for chapter 5. You guys take care. Be good.